Right. So, सलमान, can you please check ये Facebook पे आ रहा है कि नहीं, Women in Law के पेज पे? I think आ रहा है. Okay, so So it's 6 p.m. and we'll be starting the session formally now. Thank you so much for joining on such a short notice. जुडिशल अपॉइंटमेंट्स का टॉपिक पाकिस्तान के हवाले से बहुत ही अहम है कि अभी हाल ही में इसके ऊपर जो है बहुत काम हो रहा है. 2010 में पहली दफ़ा इसके ऊपर जो है रूल्स बने थे जुडिशल कमीशन ऑफ पाकिस्तान से, दैट इज empowered to make the rules for judicial appointments. And since then, there were a lot of gaps that had been pointed out by various lawyers, by bar representatives, by the judiciary itself, and by other stakeholders, including female lawyers. So, अब 13 साल बाद जाके इस इशू के ऊपर दोबारा बहस छिड़ी है और बकायदा कोई इसके ऊपर रिफॉर्म्स होने जा रहे हैं. So, we requested and we've done a lot of work on this, and as you all probably are aware of the work that we've done. हमने इसके ऊपर डेटा भी कलेक्ट किया और इसके हवाले से काफ़ी सिफारिशात खुद भी हमने पेश किए हैं. सो उनको भी डिस्कस करेंगे, बट हम चाह रहे थे कि जो यूके एक्सपीरियंस है, दाऊद, कैन यू प्लीज स्टॉप शेयरिंग द वाइट बोर्ड? Yes, kindly. I would request everybody to kindly please maintain the decorum of this meeting and raise your hand if you would like to speak. Please keep your mics on mute before we officially begin. And you can use the comment box to leave any comments that you may have. So we have with us, and it's our privilege and honor to have Deputy District Judge Mr. Tanweer Ikram with us. I mean, his celebrated profile has been shared by us, and we're all familiar with his amazing range of expertise and experience. And just recently, he's been appointed as a commissioner for the Judicial Appointments Commission in the UK by the King. So, Judge Saab, we're honored that you're here with us, and we'd really like for you to begin with with walking us through what your role entails and as a commissioner at the Judicial Appointments Commission, and then we'll take it from there. So over to you, sir.
Well, good afternoon, everyone. Assalamu alaikum. I hope you can hear and see me okay. Someone say yes?
Yes, we can.
Good. Excellent. Well, where shall I start? I won't start with the Commission because the Commission really is very much at the end of the tail. Historically, judges in England and Wales were appointed by a politician within government. And surely there was political bias. Friends of politicians, it is said, could have been given advantage. And certainly at that stage, judges themselves had a very significant role in the appointment of judges. That was changed in 2006. In 2006, the process of appointing judges was taken away from the judges and given to the Judicial Appointments Commission. Under the Constitutional Reform Act, significantly, the Independent Judicial Appointments Commission were given various statutory duties, and they are under statute. The first is to recommend for appointment, because that's what the Judicial Appointments Commission does. It recommends lawyers for appointment. And three duties. Firstly, to recommend candidates solely on merit. I'll come back to how do you measure merit in a second. Secondly, to appoint lawyers only of good character, and I'll come back to that as well. But I think thirdly, and significantly in the context of the discussion we are having, the Judicial Appointments Commission, when it makes recommendations, must have regard to the need to encourage diversity in the range of persons available for judicial selection. And that's significant, isn't it? Because when you start looking at women in the judiciary, the Independent Commission has been put on a statutory footing that they are under a duty to encourage diversity in the range of persons available for judicial selection. Now, how the JAC and other people do that, we'll perhaps look at in a few minutes. So as I say, there's an Independent Judicial Appointments Commission, and they are appointed separate as an arm's length part of government, but they don't report to anyone. So there's no political influence within the Judicial Appointments Commission. I can tell you that because I was recently appointed as a commissioner. Well, who are the commissioners? Well, the commissioners are mostly not judges. There are 15 commissioners. 7 are judges. There are 2 lawyers from practice and 6 non-lawyers. So if you do the maths, there's 8 non-judges and 7 judges. So the majority of the commission are not judges. And that's significant because in order to create some of the changes and arguably justice in judicial appointment, they didn't want the judges just appointing the same old circles back to judicial appointment. If you wanted to create change, you had to have outsiders. And so now, when the Judicial Appointments Commission sits to make recommendations for judicial appointment, the judges are actually in the minority. So as a general proposition, you could say that judges do not appoint judges anymore. And that's significant. Significant in the context of this discussion because historically, the judges were from a very narrow range of people, a narrow range in terms of professional practice. They perhaps came from a restricted number of chambers. They came from a small number of law firms. And they seemed to, it is said, replicate themselves with further appointments from the same circles. Now, of course, that's not good for diversity. Diversity, well, what do we mean by diversity? Well, at its most simplistic, and perhaps for the purposes of this discussion, you can talk about gender diversity, the number of women judges. But of course, here in England and Wales, we have a debate beyond gender diversity, but also in terms of ethnicity, in terms of class. Class is an interesting notion for diversity. If you always appoint people of a similar social background, then there isn't true diversity, even if you put women and people of colour into the mix because they may have similar social attitudes and views of the state, etc. So we collect data, and data is very important if you want to have a discussion about diversity, not only in terms of gender and ethnicity, but we also have mandatory data collection now in terms of the social background, both of the candidates who apply for judicial office and those who are recommended and appointed to judicial office. And so, for example, we use parameters such as, did your parents go to university? Did you get free school meals? Because that in England and Wales can be an indicator of lower social class. If your parents didn't go to university, if you went to school and the state had to provide you free meals. As I say, class is very important, as well as gender, as well as ethnicity. The Judicial Appointments Commission has not been without criticism, and certainly many people say that the increase in diversity has not been as fast as it should have been. But let me tell you this first in terms of the selection process. How do we appoint judges? That in itself, I think, is an important consideration in ensuring diversity. For all positions in England and Wales, the JAC creates a selection exercise which is advertised to the professions. In England and Wales, most judges start part-time first. So they'll sit for 30 or 50 days in a year and then return to practice for the remaining days. And many judges are fee-paid judges, part-time judges. They will never become full-time judges at all. In terms of fee-paid selection exercises, first stage is an exam. And even the exam is scrutinized very carefully to ensure that there's no diversity bias within the exam paper itself. The exam will be set by a judge. We call it a selection exercise. We don't call it an exam, but it's an exam effectively. And the highest marks in the selection exercise, in the qualifying tests, as we call them, will be selected then to the selection centre. There may be 1,000 applications, maybe 1,500 applications for 30 or 40 positions, i.e. 50 or 60 applicants per post. It's a very competitive process. Those who get the highest marks in the qualifying tests will then be invited to sit a role play. In the role play, we're looking for aptitude and really character, seeing how candidates respond to a true courtroom scenario. So in the role play, it may be that actors will display prejudice, they may have disability, they may not be legally represented, there may be legal errors by the lawyers, there'll be some test of legal knowledge perhaps in the role play as well. We're looking for aptitude, we're looking for candidates who have the potential to be judges, and one way of measuring that is actually putting them in the chair and watching them. They're told in advance what the selection exercises topics will be, and they're given some clue about what the role play will be about.
May I just interject here and ask you and take you back a little to the examination that is held after the application stage? What is the nature of that exam and what is the purpose? I mean, what does it test in the candidates? So like, if you could throw some light on that also, please.
Yeah, different selection exercises will have different types of qualifying tests. Some are very generic. In other words, they will test your, for example, your approach to fairness. So I've seen certain qualifying tests where the writer of the test has created a fictitious statute to give no particular candidate an advantage, thrown in issues, for example, of an application for an adjournment, an application in generic terms to exclude evidence, an application to withhold information from the public, to sit in private, for example, to exclude the press. There may be more specific tests on your legal knowledge in a particular jurisdiction. So the nature and content of the qualifying test will vary depending on what the position is. And what it's designed to do is check on aptitude and legal knowledge as well. Now, in some selection exercises, they are less interested in your particular legal knowledge within that jurisdiction because they think you'll pick it up very quickly, or the jurisdiction may be so wide that it would be unfair just to ask on one particular area. There, the test can be very, very generic. In my jurisdiction, for example, we also ask a straightforward comprehension test. We give, for example, a judgment given by a judge in a past case, and then we ask the candidate to answer various questions about what the judgment says. Why? Because we're looking to see, firstly, whether the candidate has the skill in assimilating and clarifying information, whether they can focus on the real issues, whether they can understand how to take information out of evidence and answer specific questions. Those are very generic skills which a good judge would have. You note in that particular example, you don't actually have to display jurisdictional legal knowledge. And so the tests really are looking at the sorts of skills a good judge would have. And they're designed in a way which would not advantage a particular group of lawyers over others. Yeah. As I say, it is jurisdiction specific, and there will be one which is just really being able to pick out information from, for example, a judgment or even a speech which was given by a particular judge. And you may be asked, you know, reading that speech, did the judge think that poor people were dealt with more leniently than people who were working in factories? And you've got to read the judgment to see what the answer to that question is. And you see there, you're really looking at a very wide range of skills: the ability to pick up information, the ability to pull out information, read quickly, assimilate information, and also identify the real issues. So that's the qualifying test. Then there's the role play. You know, how does this candidate play out in real life? Well, I've sat in many role plays. Some candidates are better than others. Some can show frustration. Some can show impatience. Some can show communication skills, which really show that they can deal with people from different backgrounds, different levels of education, especially if they're not represented by lawyers. The criteria for appointment and the skills and competencies that are required to be a good judge are published. And the competency framework is on the Judicial Appointments Commission website. Every candidate is asked to do a self-evaluation giving evidence how they display the required competencies. And that form is then reviewed by the selection panel. There's an interview, and that application is tested to see whether the candidate in real life demonstrates the competencies consistent with their self-evaluation on those competencies. The candidates who score highest are then recommended for appointment after character checks.
Right. So may I just ask, how much of a time duration does this process usually take from the time a position is advertised to the time that the application arrives and exam is taken, then the role play happens? And also, if you could just give us an estimate of the timeline that this entire process generally takes.
Yeah. From the day you apply to become a judge to the day when you will actually be in post will take between 8 months and probably a year. It used to take longer. It used to take a lot longer. And the process I've described is for the part-time judge. That part-time judge then has to go through the whole process again if they want to become a full-time judge. So that's what I did in 2008. I went through the process again. I also then went through the process again in 2017 to the current position that I'm in now. So from the day you fill in that form to the day you might actually be sitting in a courtroom as judge, between 8 months and 12 months. And the Judicial Appointments Commission has worked very, very hard to try to reduce the period, because of course they administer this process, recognizing that historically it could take 1.5 years plus. When I was appointed to my full-time position, I think it took over 1.5, nearly 2 years before I took up my post. It's now less than half of that.
That's very interesting. I would want to actually also take you back a little to the composition of the Judicial Appointments Commission itself, as to how gender diverse or otherwise how diverse is the composition of the Judicial Appointments Commission itself.
Right. Every selection panel has to be diverse. So every selection panel that sits must have gender balance, and also ethnic and other diversity as well. And so what you find on the 3-person selection panel, because there'll be 3 people on the panel, is a judge, but 2 non-judges on the selection panel. And we will make sure that there are women representation, and we will also try to show ethnic diversity on the panel as well. The panels then report back to the Commission with a list of the candidates which they thought fitted best the competencies for that particular selection exercise. And then the Commission will then basically look through the recommendations from the selection panels and either approve them or not approve them. They are then transmitted on to the Lord Chief Justice, or in fact, I should now say Lady Chief Justice, because for the first time we have a Lady Chief Justice, Lady Justice Carr, as our Chief Justice, or the Lord Chancellor, because they both are then involved in the formal approval, which then goes to the King, because all judges are then appointed by the King. So the answer is yes. Without gender and diverse panels, you are at risk of not appointing or not identifying the best candidates for appointment. So that is very much part of the selection system. In terms of the commissioners themselves, I think it's probably about half-half in terms of the commission itself.
Right. Right. Thank you so much for walking us through this entire process. Now, I just want to sort of take you back to what the Britishers left behind for us in Pakistan. And I do recall that during the Mughal era, aptitude and merit and such like qualities were part of, the consideration for judges being appointed to the King's Court. And then, of course, when the Britishers came, a lot of professional qualifications were introduced. And a lot of them were based on a lot of technical qualifications, like, again, you come across things like, and in Pakistan, they've just continued to add on to those requirements, which are not mentioned in the constitution. They're not part of any laws, but they insist conventionally on factors like who the senior most person is, or what role seniority can play, the number of judgments that person has to their name. So all of these factors, as women in law, of course, we find them as gatekeeping tactics, we find them as technical barriers, and we find them unfair and unjust, because you do realize that active legal practice is also, it has its own fair share of limitations, whereas women are concerned because a lot of time they don't get equal opportunities to argue cases before the courts. And so whether a lawyer has a certain given number of judgments or not, or whether a judge has a certain number of years to their experience, to be then taken up to the Supreme Court? How do you see these technical requirements, and how can we sort of use the UK experience to give an answer to those who insist that such metrics are necessary in order to decide who the best candidate is? So what's the answer to that?
I don't pretend I know all the answers to that, but let me have a go. We've historically had a similar issue in relation to women within the legal profession, because you're absolutely right. The experience an individual lawyer will have in practice may well impact their suitability and the evidence they can draw upon for judicial appointment. The answer, very simply, is we don't have any of the considerations that you have. The only considerations we have are the competencies. So the competencies include, for example, an understanding of communities, communication skills. Another competence is intellectual ability. Now, how you evidence each of these competencies is for the candidate. And a candidate might evidence their intellectual capacity through, for example, possibly a judgment they gave, but it could also be the book that they wrote. It could be the article that they wrote. They could show intellectual capacity by the fact that they got top marks at the University of Wolverhampton. So it's for the candidate to decide what evidence they present in relation to each of the competencies. And therefore, seniority falls out of the equation, because I certainly wasn't the most senior district judge when I became, I'm not a deputy senior district judge, I am the deputy senior district judge for England and Wales. And I certainly was not the most senior candidate in terms of years of experience. It's just that I don't know how I did it, but I did, demonstrated best the competencies for the role. And you're absolutely right. The danger, if you look at the number of judgments someone has written or seniority, is you actually replicate the existing pool of judges. Let me say one more thing. There are many, many initiatives which we have which support lawyers to become judges. We have a pre-application judicial education program, a series of videos which lawyers are invited to watch. We have a lot of outreach where we go and talk to lawyers. We talk about how you fill in the application, so that candidates can understand the process. Some candidates will understand the process better than other candidates simply because of who they are and their connections. We want to take that advantage away. We have a judicial diversity strategy over a 5-year period. For example, the Lady Chief Justice recently has issued a direction that she wants more female lawyers where they are part of a 2-team. So sometimes we have leading counsel and junior counsel presenting a case. She's said she wants more female lawyers being junior counsel, and more significantly, because the truth is that a lot of leading counsel are still men, she has given a speech where she wants more of the women to do the advocacy, even where they are being led by a male lawyer. And the reason for that is we want to increase the opportunity they have to demonstrate the competencies, to give them a better opportunity to progress within the profession, because ultimately the judiciary are going to be impacted on the opportunity for progress within the professions themselves. So if women are successful in practice, they're more likely to become judges. Can I tell you this, that in the last round, 49% of all applications for judicial office came from women. Of those 49%, 48% of all the recommendations were women, so nearly half. And that sounds about right, doesn't it? If half the applicants are women, you would expect half of them to be successful. And that's exactly where we are at with the Judicial Appointments Commission today. And that is despite, I think, a lot of disadvantage that women have historically had within the profession. Now that's changing because the prospects for partnership for women was different. The prospects for King's Counsel, what I think you call senior counsel, was less for women. And so the pool of candidates themselves had disadvantage. Now that is changing. And certainly the Judicial Appointments Commission, I think, has made serious impact into ensuring that women get to office by making sure that they apply the merit test. Can I also say one final thing? Where we have two candidates of equal merit, then the rule says the person who would increase diversity gets the job. In other words, if you had a man and a woman of equal merit, the woman would get appointed, because that's also within our rules.
So thank you so much. I just want to ask about one last thing as far as the outreach is concerned, and then we'll have the floor open for some of the question answers by the audience. I would like to know if the Judicial Appointments Commission is present through or has branches, or in terms of its outreach in remote areas or communities, or is it location, or is it based in one part of the country, and how does it kind of reach out or do any of the exercises and trainings and other kind of programs, inviting applications and preparing them throughout UK, England and Wales, essentially?
Right. The judiciary, of course, is not of the UK, but of England and Wales, not quite the same.
Sorry. Yeah, England and Wales.
I mean, the UK is just weird constitutionally. England and Wales are separate from Scotland and Northern Ireland. The answer is it's national outreach. I have been involved in JAC events where we will go, for example, to Leeds or Manchester or Bradford. I did an event in Bradford last year. Bradford is one of the most ethnically diverse cities in the UK. Lots and lots and lots of Pakistani practitioners in practice in that area. And I specifically went there to reach out to that particular group of lawyers. So it is national outreach. The Lady Chief Justice also has a duty to promote diversity. And that's also interesting, that we put a responsibility both on the Lady Chief Justice and on the Lord Chancellor, who of course is a minister in government, both also to be focusing on what they are doing towards judicial diversity. And in fact, the Lady Chief Justice has to present a report to Parliament every year on what she has done to promote diversity. And so the answer is, we have roadshows, we have videos, we have online sessions. I've worked with the British Pakistani Professionals Forum or something, I can't remember what they're called in the UK, to try to reach out to Muslim Pakistani background lawyers to try to encourage them to apply, but more importantly, to give them an insight into the process so that they are not disadvantaged when it comes to application. Because what we also know is that it's not a level playing field. There are some lawyers who are linked in to the sort of networks where they are supported, where they have information, where they are trained, where they are given inside information, not cheating, nothing improper, but where they have more insight into how these mechanisms work. And what we've got to do is make sure there's a level playing field. And those at the Pakistan College of Law can go and look at Legal Maxim, which it was I think the magazine you write about, an article I wrote probably 10 or 15 years ago about the equal playing field and creating that equal playing field. So the judges themselves, we have a group of 150 judges who are have a volunteer role in addition to their courtroom responsibilities. They're called the Diversity and Community Relations Judges, and they go out into the legal profession. They go out to women's groups. They go out to special interest groups, lawyers from different backgrounds, maybe LGBTQT lawyers or disabled lawyers or lawyers from Sri Lanka or whatever it is, to focus and target those communities which are not as well represented within the judiciary, to encourage them to apply. At the end of the day, all we can do is encourage people to apply. The competition is still rigorous. There are no quotas. There is no bias in favor of any particular group. Everyone is then assessed on the basis of merit.
Right. So we'll quickly take a few questions, if that's okay with you,
Yes,
Mr. Ikram. So Mustafa has raised his hand. Mustafa, you may please ask your question now.
Yes, sir. My question is this: you just said that if there are two people with the same merit, and the person who increases the diversity will get the job. So the first part of my question is this: let's say that there are two people with diverse background. Let's say a special interest group, and the other one is a female candidate. What would happen in that kind of a scenario? Would the female get the job, or the person with the special interest group? Let's say a South Asian, Sri Lankan, Pakistani, and African person would get that. The second part of my question is this: if I apply for a job and I qualify on the basis of the merit, but the sole reason for which I will not get the job is because the other person will increase the diversity. Am I now paying here for the mistakes of my past generations? I will feel aggrieved if I don't get the job. Still, I qualify on the merit. Don't you think that it's far better to have to increase the number of judges on the bench so that people from diverse backgrounds can also make it, and the person who's applying for a job from a normal background also gets a job? I mean, if, for example, if I get left out only because I don't belong to a diverse group, I will feel aggrieved and I will feel that I've been treated unequally.
Well, Mustafa, can I answer your second question first? We're talking about two candidates who are equally suited to the job. So each of them in the selection process has demonstrated that they are good enough for the job. There's only one vacancy. The public interest demands that society is reflected through its judiciary of its diversity. So you, Mustafa, may well be aggrieved, and I can't stop you being aggrieved by the fact that you've not been appointed. But the fact remains that it's in the public interest to have a diverse judiciary. We need to be representative of society as a whole. We need to bring our collective experiences, and they are different, into the judiciary. And society as a whole is better served by a diverse judiciary. So the answer to your question is I have absolutely no problem with what we call the equal merit provision. That's what we call it, and it only applies if two candidates are exactly the same in their marking. Very rarely happens, but it does happen. If you had two candidates with two different diverse backgrounds, well, it may be that there might have to be a second interview. I've seen that happen, where they just cannot decide between two candidates. They then have a second interview. It doesn't happen in real life, Mustafa, statistically. So in real life, it doesn't happen, but your theoretical question is there may have to be another interview because it may be impossible to decide which one is more important than the other.
Okay, thank you, sir.
Does anybody have any other questions? You may raise your hand. Vaiza, would you like to ask any question?
Hi, am I audible?
Yes, you are.
Okay, thank you so much. So I don't have any question as such, but I really have a comment that, it was very interesting to know that the seniority thing is not, considered something fundamental to judicial appointments. But, in Pakistan, we're still, and Nida would agree with me that we're still in this debate of whether seniority is the right principle to appoint judges, and a lot of people are for it, and there are a lot of lawyers and judges who are not for it. So if I may ask, how do we try to sort of convince people or maybe advocate more effectively to establish this in the context of Pakistani judicial appointments as well, that seniority is not a testament to some a person's fitness to hold that position.
Thank you. The Lady Chief Justice, Lady Justice Sue Carr, was appointed, I think, about 3 months ago. She was not the most senior a Lady Justice of Appeal. And in fact, she, it is said, and it's not entirely clear, so this is speculation, she competed against a more senior judge, who was also a woman, I should say. But Lady Justice Carr got the job. So our Chief Justice is a living example of where the senior judge did not get the position of Chief Justice. The answer to your question is, firstly, having a good, robust merit test. Because until you have a benchmark of how do you measure the skills and competencies necessary for a judge and have confidence that the test will be applied rigorously and fairly, then you have a challenge. Now, we've done it through publishing the competencies. And as I say, you can see the competencies on the Judicial Appointments Commission website, or if anyone wants to contact me, I will send them. And of course, the competencies for Chief Justice are a different set of competencies to be the senior district judge, because they are position tailored. So, for example, one of the competencies, no doubt, the Chief Justice has to show is political acumen, and their ability to interlink with government, because, of course, one of the things the Chief Justice has to do is sometimes talk to members of the government and represent the interests of the judiciary. So that sort of competence would need to be displayed for that position, but not mine. Seniority runs two risks. Firstly, it stifles diversity, it favors the status quo, and most significantly, it doesn't ask the question, who is the best person suited for the job? Surely that is the question which you must ask yourself when you appoint yourself or anyone to any position, whether it be a judicial post or any other. Who is the best candidate who will do the best job in this role? And that isn't based on how many years you've done the job. The two are not linked. And anyone who suggests otherwise is missing the point.
Thank you. Kashif, you want to go ahead with your question?
Well, ma'am, thank you so much, sir, for your time. First of all, I just want to ask some question that I have read in, I'm basically first year student in Pakistan. And my question is that I have read that in a public law book that judges are biased in by selecting the judges regarding the different race, people like Muslim, atheist, Christians, or different religion. Is it true?
No. It was actually a very simple question and a very simple answer. No.
Okay. Thank you.
Thank you.
So Kashif, yeah, he's just explained the entire process as to how judges are no longer selecting candidates for these positions, and there's a whole independent Judicial Appointments Commission that is doing that. So I think that process has been reformed now.
Can I also say this, that in terms of the early stages of every selection exercise, we don't even see the name of the candidate. So when they sit the selection exercise, they're just given a number. In selection exercises, where we have to consider their applications, they put a number on the top of the form, not a name. So we have no idea who the candidates are. The only time we find out who the candidates are is actually when there's the face-to-face interview or role play. Each member of the panel who's going to so there are 3-person panels considering the role play and interview. They're all given training in judicial diversity or in diversity. They're all given training in bias. And then there's moderation. There's also moderation if one panel is tougher than others. There are no quotas. So we're not trying to appoint 50% to be judges or 20% to be Muslims or anything like that. But we are watching. we are watching who actually gets appointed. Now, in terms of ethnic diversity, the progress has not been as quick as we would hope. But there are many, many complex factors which you have to factor into. And one of them, I'm only suggesting one of them, is the point I made earlier about professional practice experience. Because those lawyers who are in the big law firms doing the heavyweight cases may be at an advantage when it comes to applying for judicial office. And then you've got to look at what is the profile of those firms, who is getting appointed to partner in the big law firms.
Yeah.
There may be a bias inside the law firms, and that then trickles down into the experiences that candidates have when they come to compete in a very competitive process. Now, I'm not saying that's the only answer. The answer is very complex, and there's a lot of work which is being done to try to understand this. But I can say for sure that the panels themselves do not demonstrate a bias based on religion.
So this brings me to my next question. What is the scope of appointing legal professionals from academia? And is that a possibility in the UK?
Yes. In fact, we've had a Supreme Court judge who was a lecturer at the University of Nottingham. All positions are open to legal academics on the same basis as those in private practice. We draw no distinction. You just have to be able to evidence the competencies.
Right.
Evidence from an academic is going to be very different, inevitably, because they don't have clients. But that doesn't mean they can't show communication skills. It doesn't mean they can't show an understanding of society. It doesn't mean they can't show intellectual ability. It doesn't mean they can't show IT literacy. But the evidence will be different. And in fact, a lot of academics, especially at High Court and above, have academic backgrounds.
So, Nasir, did you have a question? Otherwise, I have a final question for Judge Ikram Sahab. If you have one, you can go. Otherwise, I'll ask the last question.
Yes, ma'am. I wanted to ask about, there is this contemporary debate going on with regards to election and selection of judges. So I would really appreciate if sir respond on this, that what is his perspective in this regard, considering his experience with regards to selection and election of judges.
I was born in England. I've been here all my life. I don't understand this election stuff. I think the Americans do it. It's not the way we do it in England and Wales. We appoint the best people, best suited through competence evidence to become judges. Those judges are appointed for life. There's no fixed term. They don't have to look over their shoulder to make the public happy. They don't have constituencies. They don't have to be supported by politicians. They're appointed by the King on recommendation from the Judicial Appointments Commission on merit. I couldn't even start to think about an alternative process based on election. It just seems to me a bizarre way to appoint judges.
Right. So on a final closing note, what challenges do you still face or consider are there in the way of Judicial Appointments Commission, and what can improve for you guys internally to do better what you were supposed to do? What's the way forward? Is there any need for reform within the commission or in the way that it's the appointments are being made? What's your take on that?
I think every organization needs to continually review whether it is doing its best to achieve the desired outcomes. So no organization can sit comfortably and say, we've cracked the puzzle. There seem to me various things which need to be evaluated more. Firstly, I think prospects within the profession are absolutely critical to this whole discussion. If lawyers of ethnic minority backgrounds do not have the same opportunities in practice, for example, they don't get to professor level within universities, or they don't become King's Counsel or partners, then that will mean that their evidence may be more difficult in a competitive process. Those who are in the large law firms get the best instructions. They have the best ability to focus on other things other than just serving their clients. I mean, I was in a very large law firm. I had 300 staff. I had 31 partners. It meant that I had time to write articles. It meant that I was able to train solicitors both inside my own law firm and other law firms. It meant I was able to do some part-time teaching while I was a partner in a law firm. Now, those opportunities that I had may not be available to a practitioner who's struggling alone to run a very, very small law firm, which doesn't make a lot of money. The breadth of experience that lawyer will have is less. So we do need to work very closely with the professions to ensure that there's equal opportunity within the professions, because ultimately they are the feed into the judiciary. The other thing which I think we need to keep on looking at very carefully is the merit test itself, because it's very easy to say, well, we are appointing on merit, but what does merit mean, and how do you measure merit? And that's something which I know that the Commission is looking at again and again and again, whether the competencies are articulated in the right way. Should there be a review of what makes a good judge? Should the way we express the qualities and how we measure those qualities be looked at again? And finally, we just need to keep an eye on whether any bias can creep in to the process itself. I'm pretty confident on that last one that we don't have overt bias, but there's always the danger, isn't there, of subconscious bias, where we look in the mirror and we see excellence in terms of ourselves, that because we're successful ourselves, we say, well, you must be like me to be brilliant. And I'm not saying you do that overtly, but there's a subconscious risk that you see qualities in the mirror. And so it's really, really important to make sure that everyone understands the dangers of bias and how we address bias.
So is there a way to complain against members of the Judicial Appointments Commission if anybody wants to, or how does that work?
Yeah, there are both internal processes where you can complain to the Judicial Appointments Commission. And in fact, we have 2 or 3 judicial reviews at the moment against the Judicial Appointments Commission by judges and lawyers who are aggrieved at their non-appointment. And so the courts are also scrutinizing how the Judicial Appointments Commission works. Ultimately, the Judicial Appointments Commission is a public body. And as a public body, it is amenable to judicial review.
Right. Thank you so much. That was absolutely wonderful. And we are so grateful to you for, sharing all these insights with us. We've, looked at the Judicial Appointments Commission on paper, but you've brought it alive for us and shared with us so many details that I'm sure will help us, work through some of those proposals in our own efforts to make our judicial appointments more fair. So we thank you for your time and really appreciate, that you've taken this time out. There are a couple of questions that people have sent in writing, which I will be forwarding to you. If you do find the time to respond to them, we'll be able to then send the responses to those in writing to the students. But thank you so much for your time. And we hope to continue our association with you on these and other subjects of interest and, mutual benefits. So thank you so much to the participants also for joining on such a short notice. Allah Hafiz.